Dear colleagues, mediators, advocates, and other participants, it is a pleasure to participate here and to have the opportunity to hear new knowledge from your experience. I feel immense gratitude for the opportunity to share my insights. Together with my colleague, Professor, Mediator, and Advocate Inga Kudinavičiūtė-Michailovienė, we prepared a report on the topic, the lawyer and mediator's expectations towards each other during the mediation process, which we will present together. Mediators and advocates meet very often in the mediation process. Even if it happens that they don't meet, the lawyers still influence the mediation process in one way or another. If the client trusts his lawyer, then that influence on mediation is very strong. And it can be argued that in any case, lawyers and participants in mediation. So the mediator and the lawyer, what is their relationship? Competitors, opponents, or colleagues? What are their roles and what do they expect from each other? In preparation for the topic, together with my partner Inga, we asked the question to our colleagues, mediators and lawyers. We have summarized the reports, and here and now we will share the results. As a mediator myself, I will start. I will start the mediator's expectations of lawyers. As we can see, first of all, mediators from lawyers want a serious approach to mediation. That is, participating in mediation would not be to add to the plus that we were in mediation. That serious responsible approach is needed on the part of lawyers to understand that mediation is no less important than the court, and that it is a benefit to their clients. I say it is because we mediators know that even without a peaceful agreement, mediation is useful because there are a lot of good, important things going on it that cannot be in court. And this can be achieved when mediation is seen as a significant process. Goodwill is very important here. It is important for mediators to have respect for them as moderators of the process. There are situations where overly active or authoritative lawyers take the wheel and don't even allow the mediator to intervene. And I have heard from lawyers that they take the initiative when the mediator is sitting and keeps silence, as if he doesn't know what to do next. There may be the situations where the mediator gets lost and really doesn't know what to do. But I have experience where I purposely take breaks because they are necessary. And as Dana mentioned, during one seminar, Virginia Satir, a famous couple psychotherapist, said that a post must last at least 20 heartbeats, no less. In my opinion, the post should be what clients need at the moment. And here is it important to trust the mediator as a professional and allow him to do what he is doing. Because the process also takes place in silence, it is sometimes even more important than talking. The trust of lawyers is therefore very much needed, and important awareness that mediation is a time-consuming process will pause for a deeper understanding of the situation. Therefore, there is no way to press or rush. Usually, a lawyer is the first person the client comes for a consultation on the issue, and the lawyer is one who has a chance to talk about mediation as an opportunity to solve problems that way. Therefore, we mediators hope that the lawyer will be the person who will direct the client to mediation, will encourage him to seek the peaceful solution without trial. It is very important for the lawyer to emphasize the benefits of mediation and what benefits the client receives. After encouraging the client to participate in mediation, it is no less important to prepare a client for this process. What is important is to understand the purpose of mediation, that we are going to negotiate, confer, talk, look for a solution, not to see what mediator has been appointed for us there and see what he will do. Also, keep in mind that the mediator is not a judge and does not need to be persuaded of the rightness of the part, because sometimes it seems that if we convince a mediator, the mediator will help us get what we want. Preparation means providing legal information about opportunities, alternatives, perspectives in court. It is important to assess the risks, that the clients clearly understands their rights and responsibilities. Perhaps even introduce case law so that clients know their limits clearly and don't have unreasonable expectations. It is very important that advocates encourage the clients to cooperate by supporting them, by providing them with important legal information, by no means discouraging them. And here I want to emphasize that cooperation between lawyers is very important, not the competition, but cooperation. Because sometimes it seems that the parties seem to be left out, but the lawyers are fighting fiercely and the mediators have to stop them. Lawyers are needed to help their clients negotiate rather than wouldn't interfere them. Sometimes, much less frequently, but there are still cases where lawyers have to remind it that a lawyer's ethics don't allow a lawyer to communicate directly, so to speak, with an opponent if he has a lawyer. In this case, I mean the principle that the lawyer communicates with the lawyer and the client with the client. Even in a situation where a lawyer can communicate with the opponent directly, which is often the case in mediation, the other part is not attacked, pressed, moralized, persuaded by an authoritative lawyer or the opposite party. It must be understood that such tactics don't really help the parties to negotiate. Mediators, especially non-lawyers and professionals in other fields, would very much like to see peace agreements drawn up by lawyers, because as we know, there is really one way to agree, and it may not be so easy to list, so it is very good that this function is performed by professionals. And I will ask my colleague Inga to continue about lawyers' expectations for mediation. Thank you.
Thank you for my colleague, Dana. Actually, I try to continue our presentation and okay. So, in fact, in Lithuania, attorneys at law, judges, as we usually said, that lawyers are the main part of mediators. Lithuanian Bar Association is familiar with this project and with mediation process and take part in transferring, promoting activities and other information in order to show the mediation necessity. I had here quite how to say, serious strictly about lawyer as the role of in mediator. But maybe we just left for discussion because in some way I disagree with some position. But when we talk about lawyer as in straight way, how we can describe it, how we can define it. Sometimes people joking, lawyer is a liar, but be careful, it's not true. Actually, we think that it's a person who is qualified to advise people about the law and represent them in the court. So it is legal advisor, first of all. And trustworthy relations should exist between client and lawyer. It is first of all. So if we just look to our as lawyers' expectations, let's move to the lawyers' expectations for mediators. Lawyers, as far modest and maybe not so much expectations they prefer to mediators. They just express a few. For example, they have written that have no expectations, just everyone should do their job professionally, and that's enough. This is the main thing for them. Well, this can also be related to the fact that maybe attorneys at law, advocates, have deep traditions and experience, and mediation is just beginning. Yeah, it is the first steps in Lithuania. But if we try with my colleague to find the main expectations of lawyers for mediators, it can be described as only a few. First of all, professional qualification, which is understood as the ability to lead and manage the process properly. Lawyers in mediation expect a constructive conversation, which they understand as not just a conversation for themselves, but a structured process, step by step, where there is a step forward after each stage. Lawyers describe the professionalism of mediator as the ability of mediator to remain impartial, which is understood as when all parties are heard, when all parties and lawyers are allowed to speak. It's also important for lawyers to be heard, because they know the client well. I can see that it is the first person usually for client, when he comes to lawyer, and lawyer provides all information related with their case, with the mediation, and so on. So, first of all, lawyer knows problems very, very wide and deep, and so on. Therefore, lawyers cannot be ignored in the mediation process if they are involved. So it's important that lawyers feel part of the process, committing themselves to the resolution of the dispute. Other expectation, it is understanding the role of lawyer. The mediator's clients are both parties, and the mediator's task is to help both parties negotiate, to help the parties discover some common interest, to enable the parties to find solution for their own. Contrary, an advocate's client is just one of part. And here is an important moment that cannot be ignored. The function of lawyer is to ensure and represent the best interest only for one part, for his client. He must monitor whether the rights of his client are guaranteed in mediation. A lawyer can only present the position of his client, influence only his client, and only expect and participate the views, goals, and aspirations of the opponent and his representative. Of course, the client's right to choose, and in mediation is the client's last word. But a lawyer has no right to force his client to lend in order to reach an agreement, which mediators often expect from lawyers. And if mediator's goal is for the parties to reach a solution that is acceptable to everyone, the lawyer's main goal still remains to get his or her client the best result. But lawyers, they see that desperately need the help of mediator to assist the parties to talk, even to start to talk. That is, the mediator would be as a third eye, would broaden the vision of the parties and allow the dispute to be viewed from a different angle. Promoting cooperation is therefore important for lawyers. A mediator is a unique link that can communicate directly with both parties to the dispute and their representatives, and also can help to clarify the common interest of the parties by hearing their views, and even becomes a huge help to the lawyers themselves in dealing with their clients. Sometimes there are situations that client doesn't hear the lawyer, or just he needs maybe more clarification. And some of the delegates mentioned emotional things, So in this area, the mediator is the first legal aid for the lawyers. When a client's aspiration doesn't allow us consider with seeing the end of attorney's process, and the mediator as a third impartial person can perfectly reflect the current situation. Because when clients want something, they think that if they convince the lawyer will have no convince the court or others, and everything will be fine. Therefore, lawyers in mediation expect their clients to see the real situation and hear the other side. Sounded maybe such an expectation that mediator would help the opponent to understand that he was wrong and that he had to accept his position. By the way, although the latter seem wrong, I think it is the most sure and sincere expectation of every lawyer. And the problem is that this expectation is shared by both parties and their representatives. Actually, despite the roles of mediator and lawyers, attorney at law is rather different, but we can find some similarities and connection at the same goal aim. If we just summing up, these common things can be mentioned as such. Both lawyers and mediators expect, as I mentioned, this professional qualification from each other. Respect, polite behavior, because respect for their profession and status is important for everyone. Yeah, working together, it's very important to trust each other. Only under all these conditions is cooperation and the common goal of peace possible. And actually, sometimes we just look at we are maybe very different, and it can be different expectation. As I heard some delegates mention that this is, first of all, for lawyers, business question. Yeah, it is money. And unfortunately, we can see that some, there are lawyers that just see that the main thing, it is maybe money for them. I mean, that longer process of litigation, more money the lawyer earns. But we can see that it is the common things. So I mean that anyway, we should look for the same goal, for the same cooperation, and the main aim is to help people, despite all differences and other things that can be treated as obstacles. So this is the main things that I and my colleague try to present for you. And one more thing that actually I should also, I'm very thankful for participation in just in one step in this project. And thanks for organizers, because it's very important, I think, for future jobs in order to reach the results between mediators and lawyers in different countries. Thank you.